Thank you. Listen. So again, a very warm welcome to this workshop on intellectual property rights. Well, the just to give you a background perspective, as you know, patenting is a very important indication of the university rankings and accreditation. When I say patenting, it includes, commercialization of the technology, licensing of the technology, contracting. All these have become extremely important indicators in the universities, foray towards higher rankings and accreditation. If you see in the last three cycles of NAC accreditation, we've come, as all of you know, of course, maybe some of the full-time research scholars are new here. For the benefit of them, we have completed three cycles of accreditation of NAC, the National Assessment and Accreditation Council, which is the premier accreditation body in India. And every single time we have done extremely well. Our trajectory has, been the highest grade throughout the three cycles of accreditation. uh, in the first two cycles, the grading system was ABC, and both the times in 2009 and 2014, we secured a grade, which was the highest grade. And in the last cycle, the third cycle of NAC accreditation, which completed in 2021, we got the highest grade, A++, with a CGPA of 3.7. At that point of time, that was the highest for any private, any university in India, so as to speak. So it was a great achievement, and definitely all our intellectual property, various research outcomes which are directly guided and inspired by Amma have no doubt contributed to that, to these rankings and accreditation. But I have a kind of a small grouse in that way. Because if you see the patenting, we from the first cycle we had a few patents. I mean, handful of patents. In the second cycle, it very significantly improved, and we maintained that streak in the third cycle. But from an IQAC point of view, from an internal quality assurance point of view, during the discussions with the Dean Engineering, we have seen that the number of patents in this campus, there is a significant gap. There is a significant gap not only in patenting, but in technology licensing, technology commercialization, technology transfer, vis-a-vis the other campuses. And we need to fix that. We need to plug that gap. It's a very urgent requirement. And that is why we are doing this workshop again for the benefit of all the research scholars, full-time. Many of you are full-time research scholars. Most of others are faculty who are doing very significant research. So this objective of this workshop is to kind of work towards plugging that gap. Plugging that gap so that the number of patents, the number of commercialization, technology, licensing, transfer, all of these need to significantly increase in this campus. That is the objective of this workshop. And we have two very senior people here who are helping us, helping not only us, all the campuses of Amrita, Jayashri Kumar and Salma Jetha. So both of them have been, with Amma for so many years, doing awesome work, uh, rather service for Amma in a very, very significant manner. Of course, Salma ma'am is not a stranger to you. She's been coming on and off. But just for the benefit of the research scholars, I thought I should say that, very lucrative. She had a very lucrative consulting firm in the US, but she moved to India to serve the university. And today, Amrita is a leader in patents. I'm sure we've crossed 100 plus granted patents. I think it's a very significant thing. I request you to please clap for her awesome service and to the university. Again, Jayashri ji, I just got introduced to her for about a week back. Since she's been a corporate lawyer in Los Angeles for many years doing service and supporting the activities of the Embracing the World charities, which is Amma's international organization, and the Mata Amritanandamayi Mutt University, Hospital, and so on. And since 2017, she has been very active supporting the IPR initiative, the contracting initiatives, and a very big responsibility that is shouldered. She's coordinating the Civil 20 efforts supporting the president of the university, Swami Amrita Swarupananda ji. It's a, a very historic thing that is happening. We just came back from this Nagpur Inception conference, and the event actually opened so many vistas in terms of a contribution from Amma, the university, the ashram, and the hospital to the country at large. So without much ado, I really welcome both of them to this gathering. Thank you so much for being here. Sure. And we will the format is that we will first have Jayashree ma'am speak about an overview of the IPR, the spectrum of IPR, followed by overview of the patenting process at Amrita by Salma ji. And after that, any doubts that we have enough time to you can clarify them. Accelerate the process. I myself have certain doubts, because when I see from an IQAC perspective, I see many of our competitor universities, adding up patents through some Australian patents. I'm really not sure if whether they are legal or not and stuff like that. So a lot of things that we need to clarify. We need to, we are at some, part in our research. Maybe the research leads to research paper outcomes. Some of them are definitely patentable. Some of them may even end up in a startup. So I'll also, at the end of these talks, I'll also give you some overview on some of the efforts that we have towards pre-incubation and incubation and technology enablement, but that will be post these talks. So first, Jayashree ma'am, pass on to you. Thank you.
Sure, very much. Thank you so much for attending this event, and thank you so much, Dr. Prashant, for the warm intro. More than what I deserve, more than what anyone has ever said about me. So thank you so much. I should record it and keep it. Um, so good morning, all. I mean, I know it's a Saturday morning, but the silence is, you know, this is more like a participatory seminar. So I would appreciate, we all are in this together. We are all university uh, representatives on some level or other. So it's okay to ask questions. It is okay to interact. Actually, we welcome that. At least towards the end of the session, please. Um, like Prashant sir said, I'm Jayashree, and I work as a lawyer in the US. I also work for Amma's universities and organizations on different capacities, one of which is doing the intellectual property law to some extent. So here I'm going to do an overview of intellectual property law. Basically, when we were in law school, this is like a 6-month course, and I'm going to give you whatever I learned or try to learn in 6 months in 1 hour. Let's see how far I can share. Um, so when we say overview of intellectual property law, we start with there is different subsections to it, which are really, really crucial and which are really dense and has its own courses and books and um materials on it that are worth like 2,000, 3,000 hours that we go through while we practice this law. One of them is patents. Everyone knows about them. Then there is the trademarks. Then we have copyrights. Then we have trade secrets and geographical indication. I'm not really going to touch on geographical indication because I don't think it really applies to most of us here. Basically, it's like the basmati rice. It's something related to India. So whenever there is a connection to any product to a certain geographical area, that comes under that subsection or Darjeeling tea. Those kind of things. But I'm not going to go into it. If you have questions, we can always talk on the side about those. So what is intellectual property? It's what is in your head. It's what your ideas are, what your concepts are. It's when we say intellectual property, the second word is very key, the property. Uh, so then there is two types of property that we know that exist in the legal world. All that I'm talking is mostly related to the legal world. There is a tangible property, and then there is something called intangible properties. So the tangible properties like the chair you're sitting, my laptop, my glasses, these are all tangible property that I can touch, I can move, I can manipulate it on a physical level. Whereas intangible property is your ideas, your concepts, your thoughts, what you want to write in a book, a music note, a GUI, things like that. Those come under intellectual property law. So when I say property, that means it has all the attributes of a property. Say, for example, if that's your chair, it's not mine. Same way, if that's your intellectual property, that's yours, it's not mine. So there's an ownership there. There is a right to that asset. Why it's important? Well, people who do creative work, for them to make sure the work is not taken by another person and distorted. For some people, it is, say, for example, if you are a software person, you want to license it, you want to commercialize it, like Dr. Prashanti was saying, you want to commercialize your that particular asset and make and give benefit to the society or for academic reputation. I mean, there are so many reasons why a person wants to do intellectual property. Main thing is to protect. I mean, just like any other property, we just want to protect our asset. Um, how does law come into it? Law gives you the right to monopolize that asset for a certain number of years. It varies with different subsections, but it's an exclusive right where no one else can take it away from you during that time period. So if you have a software code and you patent it, it's going to be yours for 20 years. After the 20 years, the monopoly goes away. But during that period, it's your property that you can innovate, you can work on, you can commercialize, you can do a lot of things with it. And sometimes it can make you a multi-millionaire. So there are legislations. India has a bunch of laws starting from 1872. It's really strange. Most people think this is a new law, but it actually started with contracts in the 1800s when I think British probably was ruling us. And that's when they said, all the creative work that we were doing, they wanted it. They didn't want to take it away from us. They didn't want us to take it to someone else. So they took ownership of a lot of our creative work. One of the classic examples where they try to patent the word turmeric. And it's a very Indian product, and India had to fight it in the British system to get it back to India. Otherwise, we would never have been able to use turmeric in our recipe books, in our without coding, without giving credit to Britain. Again, I'm not going to go into each act, but because I don't really think those also apply. Mainly, these acts are rules that define our rights, how much right we have over an asset, how we can manipulate it, how we can improve it, what are the rights, what are my rights, what are your rights, what are my limitations. That's what these acts talk about. Same way, US also has a lot of acts. A lot of our patents are either filed now. Almost everything is filed here in India with the recent law that came up. Salma will talk about filing. But if you're filing in the US also has a different set of law. The thing with the patent law is there is no worldwide patent. You have to file in different countries to get the protection in that country. So what is a patent? That's a legal definition of a patent. I don't know if you want me to read it, but basically it's making, using, selling, or offering to sell the patented invention during the term of the patent. These are all key terms. Every single word in that has to be applicable for the law to happen. So it's a right to exclude others. If it's my patent, everyone else is excluded. It's just mine. And so what can others not do? You cannot make it, you cannot say, let's say if it's a utility patent, you cannot make the chair that I designed and I patented. You cannot sell it. You cannot offer to sell my chair to someone else. You have no right to do any commercialization on my product. But it's only during the term of the patent. After that term, 20 years, anyone can, it's for the public. So these are different utility patents. These are different patents. Utility patent is the most common one that we use. Like I said, it's inventions like computers, the chairs, the brush, the hairbrush that we use, the glasses, all these are usually come under utility patents. And this is a protection for 20 years. After 20 years from the filing date, not the issuance date, from the filing date, it expires. So when you file, if you're going to think about doing something like that, it even though when I say it's actually what's in your head, technically when you start doing it, it has to be a detailed writing. You have to have your concept in writing, where someone like me will take a look at it and say, okay, this is a patentable product, or this is not, based on something called prior art. Again, I think Salma is going to talk about that. But there is a whole process. So even though it's an idea or sometimes it's a prototype, it has to be written down to a very fine detail. The next one is design patents. Those are classic example is the iPhone. You know, the design of the phone, no other phone company can use it. That has 18 years of protection, but from the issuance, not the filing. So from the date of filing to issuance, there's a time period. Once the patent is issued, then that clock starts ticking. It's mainly for manufacturing companies. You know, if we manufacture something or if we engineer something, some sort of chairs or whatever, ergonomic chairs, you know, those things that you can get a patent for the design of that product. Plant patents, you know, it's mainly if you can discover a plant, if you can find a plant that's artificially created, which has a lot of unique attributes. Um, it's a big thing, you know. If anybody's interested, that's the biggest money making patent of all patents. Since I'm a lawyer, I always go into the money making process. So, but I know most of your academic people, you may not care, but these are all assets that can make money in for it. So then the property rights, like I was saying, the patent is a property. It's an asset. It's just a repetition of what it, but I want to keep stressing that because a lot of people think a patent is something you have in your paper. It's not. It's actually, even though we have let's say we have a land, we have a paper, but there is also a tangible product the same way a patent is, there is an actual entity that the patent is. And that we have to always remember, because a lot of people think it's okay to take someone else's idea or someone else's product because it's just it's in the papers. No, it's an actual the offense is as bad or as severe as a real property theft. So that understanding should always be there. So like I said, every country needs to wants us to go and file in their respective countries to get our patent. And it's a very cumbersome and very time consuming and expensive process. If you want to, let's say, file here, then go to US and do it in China and then Japan. And it's because it's so cumbersome. There is an organization called World Intellectual Property Organization. We call it generally WIPO. WIPO has a treaty that they signed. It's called Patent Cooperation PCT. Where 150 countries, 148 countries have signed the treaties. So if we file our application process through WIPO, we get a little more time and we will understand whether our patent is patentable, whether our product is patentable. And when you have patents that you want to go into multiple countries, large corporations use these organizations forms to file, because instead of spending tens of thousands of excuse me, tens of thousands of dollars in different countries, with just this one organization, we will know, okay, we cannot file this in China because China already has something similar. Whereas if otherwise, if I file, only after I file and I pay the fees and everything, then I get the response back from China saying you can file it because it's already filed. So this is a good tool to have once we are in a space where we want to go to multiple countries. And the role of the patent system. The patent system is set up to protect invention, encourage invention, because it's highly coveted, especially by academic people, to have patents, to work with universities, and to have these in the resumes. Because I think for academic people, that kind of recognition is paramount. It's also for commercialization purposes. I mean, at the end of the day, we want to get our products into the community. We want to be able to use this for many purposes, for humanitarian purposes. So, for example, when the AIDS medication was discovered, it was a huge medicinal advancement for the patients with AIDS, because they were dying every day. But then those kind of inventions, people are incentivized to do it. One of the reason I believe is because of this pattern. Like, for me to get that recognition, other than that, there is really no knowledge on who created what, or when something was done, or where we are. Even the fact that there is a medicine available, I can improve it, and maybe I can use that same medicine for something else by improving that product into something. Those knowledge comes with patent publications. And for us universities, because most of the researchers work for the universities, the university will take care of the process. It's a cumbersome and expensive process, but we have a very efficient patent office. Salma will talk about it. We have a very good success rate. We do really good job, and we do it fast. So I would say everyone should start thinking about ideas and concepts. And what happens after I get the patent? Once I get the patent, then I can license it. That is where I know nobody's going to steal my property. Nobody's going to take my property and claim it as theirs. Nobody's going to sell it without my permission. So at that point, I can license it to other parties for them to use it. Licensing is another agreement where there will be terms included, whether it could be an exclusive license to someone, or a license for a limited term, or those are all terms that can be negotiated. And also, once it is patented, if somebody is stealing it, there are ways to enforce protection. There is court system. There are in the US, we have courts just set up for protecting the patent law. India is also, I think, considering that, because we understand the significance of this wealth. The amount of brain that we have in this country, with the huge population that we have, and the youth that is available, the current government is working strongly on setting up just intellectual property court systems. What is patentable? Again, there's a definition for it. Any new or useful process. So new means, it cannot be something that's already there. So something that's already there is, let's say, I cannot now the Medicaid, the Crocin that we all take. It used to have patent. It was a patented product. Then after the 20-year term, it lost its patent. I cannot now go back and say, I want to get another patent on Crocin. It has to be a new product or useful process. So whatever we are going to patent has to have a use for someone. Like, there was a case that we had in our office. I didn't do this case, but I heard about it. It was a glass that you can wear when you sleep, because apparently there is phosphorus in our eyes that can make designs. But the patent office came back and said it's useless. Who needs to wear a glass when you're sleeping? So they rejected it, even though it was kind of cool. We all wore it. The prototype was fun, but quite useless for the humanity. Nobody cared. So it has to be a new or useful process, machine, manufacture, or composition of matter. So it has to be manufacturable. So most of the time it's a prototype, but if you have a prototype and then you start manufacturing, suddenly sometimes you'll realize it's not going to work the way you described in your patent. You lose that patent. You have to then start all over again. So those are all important. That's why I said, when you write your idea into the paper, it has to be very thorough and very detailed, and you have to be pretty sure that you can manufacture it. Most of the time, the prototype doesn't really convert to an actual product when you start using it. Or it is a useful improvement thereof. So for example, if we have some product and we make an improvement which makes it So it's not really new, but there is an improvement. It's not taking two old ones and just making a new one, but there is improvement. There is more ideas or more concept that you put into it. Then that is also patentable. So the key terms that I've seen only in patent office is the non-obvious. So which means the item cannot be an obvious one. So one of the examples that we hear is like, say we have the tire and it's circle. Um, what if I make it square? It's an obvious design because everything else is already set and it may move, it may be useful, but it's so obvious that they don't want it. So the key thing to remember is an innovation. It's not taking something and just throwing together a bunch of stuff and saying, okay, I have a product. It has to be something where when someone looks at it, they have to say, oh, this is new. I have not heard about it. This is really unique. So those are the things that you have to look for. Whatever is not patentable is basically, ideas. Like I said, if it's just an idea in my head, or like, why cannot I have a solar panel on the floor? It's an idea, nice idea, but that's not going to be sufficient. Or laws of nature. Like recently, there was this Higgs boson that they tried to patent it. It's a physics law, something you may all know more than me. But because it's something in the space, it has already been there. It's a part of the nature. It's like gravity. You cannot patent those things. And enforcement is mostly a lawyer's job. For us, Amrita, we do have enforcement options. So if you have a patented product, it's up to all of you to keep an eye on your product because we have so many. It may be hard for the patent office to keep track of it, but you may want to keep track of the industry. And if you're in the industry, you will know if something that you did is in the market for sale or something that's very similar is being published, then it's up to you to come to the university and let the university know, hey, my patent is being infringed. Can we do something about it? So there is enforcement process. There is litigation around it. Generally, we do a cease and desist notice. We give them notice to other parties saying, hey, this is our product. Stop. That's where it starts. And sometimes it goes into trial. Most of the time, people get scared and they'll stop. So why seek protection? Exclude others. Like, I'm kind of repeating myself here, but mainly, you don't want anyone else to touch your product. Without a patent on it, even if you have a wonderful idea, even if all of us in this room know that it is Dr. Prashant's idea, we cannot enforce it unless you patent it. You can also get funding. Silicon Valley is all about funding these kind of products. And now India is also, university is doing it. University will take care of funding process. I think Dr. Prashant will talk about the commercialization aspect, so I'm not going to get into it. You can have joint ventures with other corporations, take your product to the community. That's the main thing. And you can only take what is yours. So what is yours is proved by this patent. Then there is the academic reputation. And like I said, it has to be only limited to the territory where you file. So in India, there is a rule that says if you are doing a research and your activities is in India, then you have to file it in India. After you file in India, you can go to other countries and file, but you only get protection where it's filed. And it's 20 years from the date of filing. Filing a patent application, talk to Salma about it. She's our best resource. And once it's filed, mark products with patent pending after filing. So this is again basically when to file, when do you know? And these are questions you can always take to Salma. She can look at a product and she can let you know whether you're ready to file or not ready. And sometimes there will be times when we'll come back to you and say your product may be complex, may have a lot of intricacies, but it may not be ready for a patent for so many reasons. So it's a complex process. So be patient with us, but it's well organized system we have right now in the university. So in the US, we recently had this change of law where we said in the common law, that's where the law starts. Common law said whoever used it first, whoever created it first, they have the right. US came up and with a new law that said whoever files it first. I think it was for them to encourage people to file, but there is a that is a bit controversial because some people don't file patent, but then someone just goes and file it. So it's that's why these kind of law will always spread to other countries. So it's always good to file. If you have any product that you think is patentable, talk to your department head, talk to your research professors and talk to Salma, and you should be actively involved in it. So if you fail to mark your product as patent pending, then damages will be limited. It is harder to win in the court. So it's always good to mark if your product is in the even if it's in the process of patent filing. So when we think about patent, like I said, there is the different sections of intellectual property. It is astounding sometimes. One product will have all aspects. I just want to show an example. When we look at Apple iPhone, there is a trademark, the Apple logo, the iOS, the Safari system inside it. These are only with Apple. No other. Samsung cannot use it. Google cannot use it. That's the trademark part of the patent. The patent itself is a utility, the telephone, the screen system, the touch screen, all those are patented by Apple. So however Apple does it, so sometimes I wonder why cannot Samsung use the same thing, because it's easier for us to migrate from one to other. They don't have the right to use copyright. The software code in Apple, it's constantly updated, but it is all copyrighted so that no one else can use it. The reason they copyright the code is because that has a longer lifetime. Um, trade secrets. Trade secrets are secrets that are very crucial to a manufacturer. So, for example, Coca-Cola, the recipe of the drink, it is a trade secret. Even to this date, nobody knows the exact recipe. They guard it uh, extremely well. Apple may or may not have a trade secret, because if we know about it, then it's not a secret. Then it loses the secret status. But I'm pretty sure they also have their trade secrets. And the design, if that the design patent, that's a phone itself. If you look at the phone, and if you look at other phones, they're not same. That's unique. Only you can look at an Apple phone lying somewhere, and that's an Apple phone. Same with the Kingfisher beer. I thought many people will connect with beer here. But it's like trade secret. The recipe, the ingredients are all secrets. You cannot replicate that beer. I've had people from abroad ask me, when I go back, they'll, can you bring the Kingfisher beer? And because you don't get that in the US, it's highly guarded. There is something special about that beer. Uh, the name, the Kingfisher, that is only for that brand. No one else can use it. The website, the content in the website, those are all copyrighted. The shape of the bottle, the way, the weight of the bottle, that's all copyrighted, all patented, and there is definitely contracts involved in it. Not to compete. The secrecy agreements, all those are. So one product will cover almost all aspects of intellectual property law. Same with software products. The code itself, it's copyrighted. The trademark is the name. So for example, if the like say Oracle, that name is trademark. No one else, no other company can use it. The patent is the process, how database is created, how things are, whatever that goes through in that software, that is patented. They also will have the trade secret. The code behind the software is probably the trade secret, and almost everyone will have a contract with assignments from contributors, licenses with users. When we go into a software, we have the click and wrap, that we click and say we agree to everything. Those are all part of intellectual property law. So there's a huge challenge, especially when it's a new field for most of us, how to identify valuable IP. That's always most of the time, a lot of extremely intelligent people are sitting with IP, and we don't know about it because either they are not really into that. They are just into that academic part. They're just into studying and doing more and more, but they forget the commercialization part, because most of these academic people that I've met, they're very humble, and they think It's even wrong to talk about their products because it's alien for them to um, talk about themselves. Unlike in the US, even everyone will, even the first year student will come up with so much confidence saying that they have an IP product, a patentable product. But I don't see that much here. So everyone should have that awareness that this is a tool that you can use for the benefit, not just for you, for the humanity. What you may have it to could help a big community. So from that perspective, with that awareness, that we can solve somebody's problem, everyone should look for ways to identify, and all the research department heads, they can help you. So some ways to do it, the awareness part, mainly to educate, expose to the law, which is what we are doing right now, trying to explain what the law is, how you can do it, who to reach out to, what could be a potential IP that you may have. You may be sitting here and the light bulb is going, oh my God, I may have something. I should talk to Salma. And it's not just, when we think about IP, it's not just software or it's not just technical stuff. Every field, it's not just science, it goes across. And for musicians, they have their music, they have, or for writers, they have their books that they write. For website, the content that you prepare. For uh, the food products, the labels, even if you are a small business owner, but you have a label that is very catchy, you may want to protect it. There are cases where people, like, young women started this small business, food product businesses, and in a year they went to like $1 million business, and then somebody infringed. But because they didn't do this part, there was very little we could do. And then litigation is also extremely expensive. So always, as soon as you're ready to commercialize, the first step is make sure you have a patent, a protection. That brings to the next one under the IP is copyrights. Again, the basic question is, where does the protection come from? Who can obtain protection? What can be covered? What rights are there? These are all related to copyrights. Copyright is another stream of IP law. It protects again, whatever the authorship or who owns and something that we wrote. So for example, in your classroom, if you are taking notes, who is the owner? Is there an owner? There is an owner. The person who wrote the note is the owner. He or she wrote it, and you may see the C with a circle around it. That kind of gives a notice to the third party that it is copyrighted. It's not a requirement. It's good to have, but not a must to have. But if you want to legally enforce it, you have to register it. Of all the IP law, this is the cheapest. It's like $40 to $80 in the US. It's pretty similar here too, right? Yeah. So that I would strongly suggest, if you're writing something, because that is where the ownership starts. The moment from your brain, it goes into a paper, it's actually copyrighted. But if you think it has value, register it. It has a life of 70 years plus the life of inventor. That's mostly for all of us. For big corporations, like say, for example, Disney, it's longer. Disney almost was going to expire. The Minnie Mouse they were going to become available for all of us. And the copyright office in US extended it for another 70 years because that image still has a lot of value. So what are copyrighted? Your work, whatever you wrote, you drew, you created, but on a paper or a fixed on a computer, it again is not in your mind. It has to be somewhere in a tangible place. Um, so for example, uh, let's say if I have the painting, the Picasso painting, uh, even if I sell it to you, the copyright remains with me. So I can reproduce, you cannot reproduce. So that is where for the authors it matters. Whenever we write something, we may think, I sold it, so I don't have any ownership. No, it always stays with the copyright always stays with the author. These are different things that you can copyright. Software codes you can copyright. Like I said, anything you write in a piece of paper, you can copyright it. Movies, pictures, this is a whole list. Uh, And again, you have exclusive right. You can reproduce it, you can prepare derivative works on it, distribute copies without losing ownership, publicly perform, publicly display. And again, the right is vested at the time of writing it. At the time of putting it into a computer or on a tangible medium, you are copywriting it by default. But then you can register it for more protection. And again, see, for corporations, you get 120 years from creation. That they are doing it to protect companies like Disney. You know, they want to make sure Disney doesn't lose. Not just Disney. There are companies like that, like the Olympic sign. That's one thing they want to protect. Um, so there is advantages on registering your copywriting. Mainly, you know, if you register, if someone infringes, you can sue them, and if you win, you get your attorney's fees. And the damages, there is damages that you can collect. If you do not register, you cannot get this protection. So like I said, notice is not required, but it's always good to put the C in the circle. That's a notice that they're talking about. It's good to use it. If I see something with a C around it, I generally will stay away from it because I don't want to get into that hassle. So even if it's not registered, that C is good enough for me to say to understand that it belongs to someone else. Or you can put all rights reserved. You see all kind of these legal languages around products like that. So again, for software also, the thing with the software is, you know, the patent is only good for 20 years. And then what happens? Some of these products have a longer life. So they copyright the code itself because that has a 7 year plus inventor's life. So it has a longer life and it gives the same protection that a patent gives. So a lot of software companies actually do a lot of copyrights nowadays. And if there is co-owners, you know, you have to make sure you have an agreement. And at any point when you feel you're going to come up with a good product, that's when you should start working on an agreement, not when the product is finished. Then it's hard to come up with an agreement. And if you have students contributing, if you have other researchers contributing, make sure everyone is aware of what the rights are and make sure to talk to the patent office and understand how to patent, how to copyright, how to trademark these products. These are the statute, the section 107 is a limitation. So this is for mainly for students, especially when you guys are doing research, we're constantly citing other paper. In legal research, we call it citations. In academic research, I don't know exactly how you call it, but basically you take 90% of the paper sometimes is what someone else said. How do we give credit to those people? How do we take it without stealing from them? How do we acknowledge that someone else wrote it? That comes under the fair use. Because the government wants us to, or the state wants us to make use of these wonderful work product that people did. They come up with an exception called fair use where we don't have to get permission from someone else as long as we use it for teaching or for reporting, news reporting, scholarship, research purposes. It's very limited, but if you use it for that limited purpose, there is no infringement. No, I'm probably going too fast, but like I said, there's a lot to cover. I hope I make sense to all of you. Um, so that kind of an infringement, that kind of a copying is not an infringement, but we have the right to use to some extent, but you cannot take the whole article. That will be plagiarism. We don't want to go there. We can take what we need, limit it, and use it. And then we go to trademarks. So trademarks, what are trademarks? Most people think it's a word. It's like that word apple is what it is. In trademark world, we don't call them words. We call them mark. That's where the word trademark came from, I guess. And it's mainly in the commercial world where we want to protect. So when I go to the store and when I see an iPhone, I know it's Apple. I know the quality. I know what it can provide me. That communication is through the trademark. There is a comfort in knowing that when I go to McDonald's, I'm going to get French fries a certain way. I'm not the taste is going to be a certain because that's trademark. All those things that that commercially it is established. Those come under the trademark law. Again, you can also put TM. It's not a legal protection, but that is sufficient. That gives the same notice like the circle C. Uh, or once you register, you can put R in a circle. Once you see that, then it's registered. It's a higher protection. Same like how I said, you can register if you want to register. If not, you just put TM or SM. SM is service mark. So, like I said, you can identify a product. If you hear Starbucks, you know it's coffee. You know what kind of coffee you're going to get. You kind of know the different types of flavors they have. When the design of that lady, the Starbucks lady, when you see the lady, you know it's a Starbucks lady. When you see there is a certain jewelry brand in US, it's called Tiffany. There is something called Tiffany Blue. When you see the blue box, you know it's that brand. So these are ways the companies communicate with everyone. It's very catchy. You see it, you hear it, you know it's trademarked by these companies to tell you there is their product. So it helps the consumers. It helps us see that's a blue color. That's a Starbucks lady. That's the golden arch from McDonald's. For all these are all trademarked, and you know what it stands for. When you see those rings, you know that's all it is. And again, the good thing with the trademark, it's potential. It has a potential for perpetuities. As long as you use it, you can keep it. It's yours. If you stop using it, you lose your rights. So if you really care about your brand image, you have to continuously use it. And if someone else uses it, you have to give them notice to cease and desist. What is not trademarkable? Like something that is not, that is generic terms. Generic terms are like bread. You cannot trademark it even though you made a certain bread and it's really, I cannot even make a bread like a Jayashree bread because Jayashree is a very common name in India. How can I take that and cut the rest of Jayashrees out? So I don't have that kind of protection with the trademark. It's more like, let's say Exxon Mobil. There is no meaning to it, but everyone knows what that stands for. Or Google. Like recently, there was a case when we all use this term Googling. Let's Google something, but you actually Google does not allow us to use that term in that way because they want to keep it for their company. The moment we use it on a generic term, like the elevator, actually is a company. There was a company called Elevator. Now everyone says elevator to the point the company lost its trademark. Kleenex. They lost it because every tissue that we use, we now call it Kleenex. So you have to make sure your product is protected. Google spent a lot of money to win that battle. So actually, if you say, I Googled it, you're violating the terms. And it cannot be very similar to another trademark. Like, so somebody actually had in the US, they made a toilet paper and they put the Microsoft logo on it. The patent office said, no, you cannot do that. Trade secret is your secret ingredient in your business. What makes your business, where you are, how you are. Like I said, the recipe for Coca-Cola is a classic example. There's been many battles around it. They will fight as much as they can to protect their flavor. There are other companies that came up, even the bottle that Coca-Cola has, that's trademarked by them. So how to lose it? If you disclose a secret, like it's just as long as you keep it a secret, it's a secret. No one else can touch it. The moment it comes into public, so if you disclose it, or if someone reverse engineer it, where we actually that's how Tylenol lost its trademark on that product, that medicine, because some really smart engineers in India reverse engineer it. And or independently develop it. If I can come up with the same flavor, then they lose that secret status. So it also has a significant economic value. The Coca-Cola, if I go to a store and if I want Coca-Cola, I know that flavor is only with that brand. And no one else knows how to make it. So I don't even go and try Thumbs Up or something. So there is a huge effort to keep the whole thing a secret. We do it through licensing. We do it through agreements. We do it through non-disclosure agreements, non-compete agreements. There is so many agreements that every employee, everyone who get close to a secret, they have to sign a lot of agreements with the company before they actually get the job. And then that's heavily enforced. and these are the non-disclosure agreements. This is all part of the contracts that come with IP law. Uh, in a I get often asked for templates for NDAs, and I'm very hesitant because it's most of the time we tailor make it for our clients. It's between the whenever you get a confidential information, and that information is our asset. We want to be able to protect it as much as we can. So always make sure if you're going to discuss something with a with another person, not I'm not talking about inside the university. If you're going to discuss something with your with someone who's going to fund it, you want to sign an NDA with them before you discuss your details. Otherwise, they can take your idea and they can go and replicate it, and you won't have any protection at that point. So even at the idea stage, if you're discussing with someone who has a potential to implement it, I would recommend go to the patent office, get an NDA, or talk to your department head, get an NDA and sign that. And NDA covers all the things that I said. You know, it's confidential information. It will have trade secrets in it. It'll be very as specific as you want it to be, or as general as you are comfortable with. It's mostly tailor made for your requirement. And then if you sign with someone else, do not disclose. And I'm running out of time. Then final thoughts on NDA. Basically, it's for self-protection. It's a hassle, but read it. Make sure it covers what you want to be protected, because sometimes you may be a doctor, but the NDA that you got from Google or by searching on Google could be for software. It will not protect the conversation that you had because it did not mention those key terms. So always go through it, read it, understand it. And you can always reach out to us and we'll give you the one that's appropriate for that department. So I know I covered a lot. At the very least, I would like you all to remember this slide. In the US, because I come from US, I always think about that first. It's first to file now. For us, that's a big deal. That's why I keep saying it. In India, please file in India before you file anywhere else. Um, Create a culture of IP awareness in your department with your peers. Have constant communication on what everyone is researching. Look at the options we have. That's our wealth. Technically, for universities, the academic brain is the biggest wealth. Trademark too early. As soon as you know it's trademarkable, reach out. Um, and then if you are not ready, at least use the TM, SM, the C, don't the all those protections. Even without registering, you can start there. Copyrights. Um, if you have joined others, make sure you have an agreement between both of you how you're going to copyright it, whose name is going to come first, who is going to have what right. Trade secret, keep it secret. Um, so the joint development contracts, who owns the baby at the end of it, when we start, we may think it's a small idea, it may not go anywhere. Surprisingly, half the time it will thankfully go somewhere. And then to go back in time and to fix a contract is very difficult. So always get your papers aligned, make everything, put all those I's and T's, cross that, and then go into the patent process. I think the questions will be at the end of the session. Thank you so much.
on now? Okay. All right. Thank you everyone for your patience and attention. So I'm going to talk, actually, first what I want to do is follow up on a few things Jayshree said. But before that, I'd like an idea of who's here. So um, who are the faculty in the room? Oh, wow, you have a lot of faculty. And is there computer sciences here? Computer science? Okay. Sen people? Okay. Um, so we have software engineering, civil engineering folks. Okay, few civil. All right, aerospace. Okay, wow, you're all here. Okay. And then let's see, who else do I get? Is Dhanvantri Lab, Dr. Preston. Oh yeah, there you are. Yes, welcome. Okay. And then some people from agriculture are here. That's a new group. Any agriculture? Okay. Yeah, I haven't worked so much with all of you. And let's see, who did I forget? Chemistry? Oh, great. The chemistry people are here. And the environmental. Sometimes I get things from Dr. Murali Rangarajan. That's the new, there's, yeah, chemical. Oh, that's all chemical. So those people are here. Okay, great. Right. That gives me a good idea. Thank you. And then students, do we have students or research? Ah, okay. There's a few students. So who else students are here? Who else is here? I saw the faculty, staff, research, PhD scholars. Okay, great. So I'm talking to PhD scholars and staff. Okay, great. Um, so I have a few follow-up questions. You have the mic, right, down there? Okay. Um, there's some trademarks in this room. So who can tell me the trademarks that you see in this room right now? Yeah, that's great. Up above. Thank you. You don't even need a mic. Thank you. So Amrita Vishwavidyapeetham is registered. And actually, the word Amrita is also registered. Even though Amrita is a very common word and name in India, it was registered quite some time ago, and it's used throughout. Um, I would say the word Amrita is pretty much associated with Amma's activities, right? So that has happened, even though it's a common word. And we registered Amrita Vishwavidyapeetham and Amrita University. The trademark registrations are in different classes. So most of our registrations in trademarks in the university are in class 41, which is education. So I had somebody using a trademark for some clothing and the lawyer notified me. We didn't do anything because, you know, no one's really going to confuse us with some clothing material. So that's one thing I wanted to say. Then related to NDAs, um, NDAs actually don't mean too much when you're talking to people who are businesses or collaborators. So we sign them, but really when you talk about your ideas, you can talk about them, but don't tell how it works. Okay. So don't disclose how it actually works. Because even if you have an NDA, it's really hard for us to do anything unless we file the patent. Okay. So if you file the patent, you can talk, but you still in intellectual property, we have patents and we have technical know-how. And we need to protect our technical know-how. So that means if we file a patent, technically the government wants us to disclose everything, but usually we don't. And the government doesn't ask us to tell us the best way to do it. So for example, let's say there's a patent for a formulation and it has water in it. In the patent, we normally put it uses distilled water, RO water, salt, whatever, all the different kinds of water it can use. But we don't have to say the best type of water is reverse osmosis water. So that's our technical know-how. So when you send me a disclosure, you should put all the different kinds of, water that can be used, but you actually don't have to tell me the best one. So when somebody looks at a patent or one of your papers and they contact you or the patent office, they're interested in the idea. That's when we start signing agreements. Jayshree is very involved in that. She's a lawyer that's very good in contracts. So before you disclose anything, including the technical know-how or how it works, there should be these agreements in place with your collaborator, the other company, whatever. Does that make sense to everyone? So be really careful. You can talk about your ideas, but sometimes even the idea is really novel. But many times, the governments allow patents for innovation. So somebody does a patent, after 20 years expires, somebody else can take that and build on it. So let's take television. How many patents do you think there are for television? Anyone? How many patents do you think exist? If you search television on Google patents, what's your hit going to be? Somebody tell me. Any guesses? Can you get the mic? If you search television on Google patents, how many hits do you think you get? It's more than thousands. So, anybody else have a guess? You get 3 lakh hits on television. And we've all seen television. It was kind of a glorified radio in the beginning, right? And now there's these OLEDs that are, it's kind of like a picture on your wall in your bedroom, right? You don't even need hardware. You can just, so that's how television has advanced. And that's why governments allow patents, because each one builds on the next. Okay, so 1 minute. So let me start. Okay, so we're a university. Why do we file patents? These are some of the reasons we file patents. So one is to increase access to cutting edge technologies in low resource settings. So something can be patentable because it's cheaper, less expensive, easier to do. So a lot of our patents that are maybe things that can be done in a village, not in a hospital. That's patentable. You know, or it uses indigenous technologies or parts. So that those kinds of things are also patentable. We also protect our IP for commercialization. One correction to what Prashantji said, we have 90 granted patents, not 100. But one small correction, maybe we'll get to 100 soon. We have more than 100 pending patents, but right now only 90 are granted. So about 40% of our technologies are in the field. So the landslide system, you've all heard about that, I'm sure. That's in several places in India, but that's not commercialized, but it is protected. And the way we get the funding is through government agencies. The ocean net system, you've all heard of that. It's a communication system for fishermen offshore. So they don't have like complicated communication on their boats. They have their phones. So the OceanNet system actually allows the cell phone to work for up to 200 kilometers offshore. That's from the WNA lab, that system. It's actually currently being tested and evaluated by the Indian Navy. So, and that's how we got funding for that. Some of our things are commercial, like our HIS system. The insulin pump has been sent out commercially. Then, where's Satish? Satish, yeah, here. Satish, you probably know him. He's in the biosensors lab. A lot of their products are sensor related, and they're out in the field being developed by companies. And then, as you all know, we're Amrita. Amma likes to give things away. So because we have a patent, she can give away whatever she wants. No one can stop us. So sometimes we have patents because we want to be able to give things away and we don't want anybody to stop us. So that's another reason. And then the patents also give a lot of recognition to Amrita and the inventors. So our 90 granted patents, I would say 40–50% are US patents. The other half are Indian patents. If you have a patent in your name, whether it's filed, pending, or granted, it's a citation, just like a paper. And there's a way to cite patents, which I can actually send to Prashant. Maybe you can communicate that. But you should cite your patents, whether it's filed, pending, or granted. Okay. And then lastly, the patents help our university ranking, but really we try to use our patents and get them in the field, the technology. Okay, so these are the granted patents by technology. So you can see the main, oh yeah, here. So biotech, life sciences, and then the health sciences, these are a big bulk of our patents. Like 50% of our patents are granted in those areas. And then we also have mechanical, the wireless, computer science is less than I would expect, but that's there. And then this is the energy solar. We also file in learning technologies also. And then I talked a little bit about this. These are the patents that are deployed. The core shell particle formulation, that's from the Ames Nanosciences. It was actually sold to a US company. The Oceanet system is this one that I just talked about. And these are the sensors, the non-enzymatic glucose sensor, and the HIS. The HIS is out in the field. It's used at the hospital. Okay, so this chart shows the growth in our patents over this period of time. So I had the responsibility of filing and getting our patents granted. I started in 2012. So this is kind of, if you can see from 2011 to 16, we only had 1 or 2 granted per year. And mostly the blue is foreign, but mostly US. And the ochre color is the Indian patents. So recently, the Indian Patent Office, the IPO, has gotten much, much better about the timeline. Before, it used to take 5 to 7 years to get an Indian patent granted and 2 to 3 years for a US patent. Now it's pretty much on par. So the Indian Patent Office is much, much better and much faster. And the way the Indian Patent Office works is there's an office in Chennai, Bangalore, Mumbai, Delhi, and Calcutta. And they specialize in different technologies. So if you have a software patent, and I want to talk about this too. Software patenting is very difficult in both India and the US. The reason is the patent offices look at software as copyrightable material. So when you write, you're all familiar with writing code, right? Yeah, so I hate code writing. But anyway, when you write code, it's like writing a book. So the patent office sees software, strictly software as writing a book, you can copyright it. The only way, both in India and the US, that you can get software patented is if it's implemented in hardware. That's what we usually do. So we get the patent granted because we have hardware and software, and the software is getting the hardware to work. I has an example about this. Anyway, the internet, that I won't go into that. But so basically, we can't just get straight software, and straight algorithms are very difficult to get granted. But if it's in a system that does something, that's how we normally get it granted. Does that make sense? Everyone understands? Okay, great. So as you can see, starting in about, let's see, 2017, we started getting a lot more grants. And in recent years, we've gotten more Indian patents granted than the foreign ones. So the Indian Patent Office has a legal requirement that if the inventors are Indian or the invention was developed in India, we have to file in India first. So we always file in India first. But then if we want to file abroad, we have 12 months from that date. So okay, and also, Jayshree talked about this, is my idea patentable? How do you know beneficial to society? The one thing I want to mention is non-obvious. So the patent office, non-obvious means that your colleague, who's also an expert in that area, can't figure out how to make it work. So it should be not obvious to some, so it's a level of test that we always go through when we're going back and forth with the patent office on whether it's actually new and novel. That's the criteria they use. Okay, and then the other thing I want to talk about here is, so Jayshree showed those acts that were enacted in India before 1970. So the Act of 1970 repealed all the previous laws. And what that Patent Act did is it made product patents not patentable in India. So what does that mean? Drugs are no longer, as of 1970, you couldn't patent a drug, but you could patent the process to make the drug. So the 1970 Patent Act set the stage for India to become the pharmacy of the world. And so what Indian scientists did is they reverse engineered how to make those drugs. Processed patents were allowed under the Patent Act of 1970. That's how we have a huge pharmaceutical industry in India. And also in India, the government wants drugs and medicines to be accessible to everyone. That was really the key thing. Like, we didn't want to pay for expensive drugs from outside. So then what happened is, Jayshree talked about those other international PCT and Paris Convention, blah, blah, blah. So the Indian government had to sign those. And after the Indian government signed those, there's been amendments to the Patent Act about what's patentable and not. So now drug products are patentable, but the Indian government has a very strict requirement about what can be and cannot be patented. And that includes what I talked about, software and also with medicine. So, for example, what happens in the US when the drug patent expires? What just everyone knows, right? They just renew it. So what they do in the US is the drug maker will just put a hydroxyl or something on the end of a drug and get it renewed. They'll say it's different and get an extension on their patent. That is not allowed in India. The Indian government, we have to show improvement or change in efficacy to get the patent renewed or even to get the patent granted. So the Indian government is very, very strict on this. There was somebody from Ayurveda that sent me a vegetable wash to clean vegetables. And it was all like turmeric and other typical Ayurveda medicines. I have to have the data on efficacy to get that patent. Okay. That makes sense to me. Okay, so do you patent or publish? This often comes up. So it's not really a choice. You can do both. You can actually do both. So I'm going to just tell you the differences. So with patents, Jayshree talked about this. It's a 20-year right. After that, anyone can use it. The patents are automatically published within 18 months. And in both India and the US, the patent won't get reviewed by the patent office until it's published. So now to get our patents published fast, granted faster, we request the IPO, the Indian Patent Office, to do an early publication. And we also request for an examination earlier. So that's how our patents are moving through the system faster. In the US, we typically don't do that, but as soon as it's published, the patent office in the US, they have something called art units. The USPTO is all in Washington, DC, and they have these art units that's based on technology. So whoever gets assigned to your patent, US patent, is an examiner that's also specializing in that technology. And sometimes people file patents, they don't want to publish them early because they want to keep the information secret. So if you don't want to publish early, please tell me, because it's kind of a standard process for us to request early publication, review, and grant. Yeah. So, oops. Okay. So in most of our patents, like if it's a device or something, a product or a process, other than biomed, if it's a pharmaceutical, like a biopharma, Dr. President knows, I need data. But otherwise, I don't have to show that it works. It's not like a paper where it has to be reproducible research. So the government's just trusting us that it's prototypable. Some of our things we've gotten granted, they're not quite prototypable, but we got them granted. So it's kind of a fine line, but sometimes we know that technology is coming and we want the patent. And the first to file is there throughout the world. The US changed that because there was so much litigation about whose idea it was. So the US changed the system to first to file, not first to create. So that's why if you have an idea and you think it's really novel, we file something called a provisional patent. I'll talk about that in a minute. So reduction practice. And then the review for patents is the patent office. So for publications, you all know, you're all familiar with that. It's reproducible research. You have to have the data in the paper, right? We have to patent before we publish. Why? Why do we technically we should patent before we publish. So somebody tell me why that's really important. So if you publish it, it's disclosed. It's disclosed. It's not novel anymore, right? So both India and the US give 1 year from date of publication to patent. And they do that mostly for universities like us. But you have to be careful. If you published it, someone could, take your idea and run with it. So we really should file before publication. Okay. And another big difference between patents and publications. So who are inventors? Inventors is somebody who thought of the idea or they figured out how to make it work. So if you design an experiment and the student implements it in the lab, they're not an inventor. You shouldn't put them on a patent. The patent is a property right. It's like your house. You buy a house, people own that house, it's property. Okay, it does. So you can put them on your papers. I know papers have different criteria, but with patents, and the reverse is also very true. If the student figured out how to make it work, you have to put them on the patent. Why? Why is that really important? That student can come back later and say, that's my property. That's my idea. That's why you have to put them on the patent. If they thought of it, or if the student designed the experiment and figured out how to make it work, you have to put them. Does that make sense, the difference? So you can put 10, 12 people on your publications, but don't put them on the patent just to be nice. A lot of people do that, especially I get a lot of that. No, I don't know how to tell them no. And the criteria is different. It's a property. You're sharing your property with like X many people, and everybody on the patent owns it equally. It's an ownership issue. Okay. It's equal ownership unless you all decide differently. And in Amrita, all the patents are owned by Amrita University. So before I file a patent, I need an assignment document that the assignment is to Amrita. Then the university files the patent, we pay for the patent, we maintain the patent, we pay all those fees. And when there's a commercialization, there's a sharing of the monetary benefit with the inventors. And I think we'll come back. Jayshree and I will probably come back and talk about that because those policies are kind of actually being streamlined right now. So, oh, and Prashantji's going to talk about that too with tech. Sorry. So is that clear? Don't put all the authors on a paper on a patent. Okay, that's clear. Okay, so this is the patent filing process in Amrita. So you have an idea. Is my idea novel? I would say half the disclosures I get are not novel. So make sure you check. Go on Google, talk to other people, see what else is out there before you come to me. A lot of times I get things in my mind. This is already out there. So somebody might have already done it, but if you're doing it in a different way, that's different. Okay. So is my idea novel? And then we have the invention disclosure form. So I'll just show you that. The practice. This is our university invention disclosure form. So it's a document you complete. You're going to tell me what's the title. This is the names of the inventors. And the order is basically, whoever is mainly their idea, they should be first. I also need to know if there's any funding agencies involved because that impacts the commercialization and the ownership. So we always ask about that. Did some outside funding agency and then the other thing is we ask about when was it conceived, the date of conception, first publication, or your planned publication and disclosure. So we try to file before that. And there's a type of patent called a provisional patent. It's like a concept filing, and we can do it in like a week if I have to. So, and the number that I get for a provisional is the same as the full filing. So we have the ability to do that. We also ask on this form, did you reduce it to practice? Yes or no? Okay. So this form is what's required to the patent office. These are all the inventors here. And don't worry about the ID number. I don't really worry about that, but I need to know your citizenship, your passport. Okay. If you're like me, OCI, NRI, it's technically your passport. Okay. Um, Inventor name, legal address. Okay. The other thing I want to talk about, I get a lot of inventor names, Ashwati P. Please don't, you in publications and patents, you need at least two names, your full first name and your full last name. Okay. So Dr. Venkat, his patents are filed as Dr. P. Venkat Rangan. You can do that. You can have one initial, but Ashwati P, that's not really a search. That could be anybody. So this happens a lot with the filings. I'm not exactly sure why. I think in school, a lot of people register their names like this, but not for patents or papers. So you should decide how you want to be known in that world and use that name. Yeah, it's really, really important. Okay, and then this form, this form has to be signed by your HOD, okay? Because otherwise the HODs don't often know that there's a patent filing. So I need them to sign. And the last page of this talks about what's required. So I need a disclosure, drawings, architecture, block diagrams. How does it work? And I need a list of why you think it's novel. Okay. A lot of times in Amrita, what I get is a paper or a draft paper. That's great, but the lawyer wants to know what the claims are. So what are you claiming that's really novel that you think, well, my idea is better than the other ones because of XYZ? It's really useful if you send them. That makes sense? Yeah. Okay, so this is our invention disclosure form part of the filing process. Okay, so we get the idea and then review it. And then what we do in Amrita is we have different law firms that specialize in different technologies. So I decide based on what they filed for us who I'm going to use. And a lawyer will review your idea, your disclosure, and we do a prior art search. So what that is they look at everything that's out there internationally. So if you have the idea here, but somebody did it in China, we can't file the patent because it's already a Chinese patent. It's done by a Chinese inventor. Yeah. So we check internationally what's out there and whether it's patentable. And then I get a report back from the lawyer called a prior art report, and I send it to you as the inventors, and we review it together. Usually they have a scale, and patentability is not yes, no. It's usually a scale of 1 to 5. Okay. And then we make a decision together. Is there enough here to file? Because if I file and it's not very patentable, we lose all that money. And if we get that back and the university is like, we're not going to proceed and you want to proceed, just let me know. We'll get you a letter giving you permission to proceed if you want to do it on your own. Does that make sense? Yeah. So once we decide if we're going to actually proceed, then the lawyer drafts the patent specification. And it goes back and forth between our office and the inventors. And then the patent's filed. Okay. Any questions on that? And this is the timeline. So let's say we file a provisional. That's like that concept filing I told you about. After that, we have 1 year to file the full patent. So you should have enough, you should calculate in your mind, okay, I have enough time to do my research. And sometimes we file a provisional and we don't follow it up. It doesn't hurt anything. It doesn't even get published, but it means we were the first to file. We got the date, we have the priority. If somebody else comes along later, we can claim that it was ours first. Okay. And the provisional patents don't cost us that much. The full complete patent is sometimes quite costly, but not the provisionals. So we have 1 year. So we file the provisional. After 1 year, we have to file the complete spec in India, and we have to file anywhere else we want to file. US, Japan, China. Normally we file in India and sometimes we file in the US. And then the PCT filing that Jayshree talked about, that's recognized in 150 countries, but really that's only really done for pharma patents. And if I have a commercial partner inviting, because they're quite expensive. Okay. So after 18 months, it gets published. And then in India, the process is we file a request for examination. the patent goes into a queue, then it gets reviewed by the examiner, and I get something called a FER, which is a first examination report. And usually there's usually there's objections to the patent. So we've only had 2 or 3 patents go straight from publication to grant because they're so novel. So normally we have a back and forth. And in India, we have to respond to this FER. And sometimes there's a hearing. Sometimes there's no hearing. So if we reply to the FER, the examiner looks at it and they accept our responses, they just grant. But if they don't, they'll give us a hearing. So the hearing is usually online with the lawyer and the patent examiner. Sometimes the inventors have to attend, but not usually. And then in the US, the process is a little different. The patent gets published and it goes automatically to examination. And then the examiner in the US will issue an office action. Sometimes there's one office action, we reply, we get a grant. Sometimes there's 5. So typically we go through 2 or 3 office actions to get a grant in the US. Does that all make sense? Oh yeah, and this is my info. So if you have any questions or you need an invention disclosure form, you can email me at selma@amrita.edu or patents@amrita.edu. And these are some of the important websites. So amrita.edu patents has some of the info. IP India, that's the Indian Patent Office's website. The WIPO portal, this is really good. WIPO has tons, the World Intellectual Property Organization. They oversee the PCT or the international patents. They have a really good website, really good info. And they have a portal called Patent Scope, and you can research tons of patents there. USPTO.gov, and then Google Patents is also very useful, but Google Patents doesn't have Indian patents. It doesn't have all the countries, only some of them. Okay. Are there any questions? I wanted to cover a few other, I just want to make sure. Jayshree talked about utility patents. So the types of utility patents we file are for commercial processes like industrial processes, product, and method patents. So if you have a business method, a teaching method, those are patentable. And I want to show some of our patents. I forgot that. These are granted patents. Let me just, okay. So this one, this is the patent certificate. This is Dr. Pressman's patent for the, it's a novel, I'll just show, it's a method and formulation for screening and treatment of prostate cancer. This was granted some time back. It was filed in 2015. This is the, so when it gets granted, we get a patent number. Before you get this number, this is the application number. That's what you're going to use when you do your citations. Okay, and then the date of filing. So the patent is good up till it was filed in 2015. So how long is it good for? Tell me the year. 2035, right? That's correct. So this patent's good and valid until 2035. Okay, and just go down. And here you have the date of grant was 2022. You can see down here. So this is what we get from the Indian Patent Office is the certificate. This is what this is a US patent that we have. This is on the remote health monitoring system with IoT sensors. So this is a US patent. Here's the patent number, the date of the patent. And this is the grant date, I think. US patent. So the first inventor is always marked on top. Ramesh et al. Amrita. And then all the inventors' names are here. Here's the universities. This is the application number for the patent. Yeah. So it was filed. See, this was filed in 2018. It got granted in 2019. So US system, especially for wireless technology, is super fast because wireless technologies go through the life cycle so fast. So they grant very quickly, very quickly. And this is what it looks like. There's an abstract. The patent has the, they all have the same format, the abstract, and then all the drawings. And the main part of this patent, the key part, see all the figures are here, but really the key part are the claims. The claims are always at the end of the patent. Yeah, this patent has 22 claims. It's a lot of claims, but this is what we have. So all the patents are like this. What is claimed? A health monitoring system comprising, and it describes the whole system and what we're claiming. And all of this, all these claims were granted by the patent office. So if there's any infringement or who owns it or whose idea it was, it comes back to the claims. So when you get a patent specification from me, please review the claims. I know you check everything, but the claims are really important. The claims should include everything you feel is patentable. If something's missing, you should write it in and tell me. Okay? So that's a US patent. And then I just want to show you a design patent. Design patent, Jayshree talked about, it's just look and feel. This was recently granted for, is Dr. Ramu here? Oh yeah, here he is. That's Dr. Ramu. And this was actually filed with Dr. Thirumalini, who passed away, but we still put her on the patent. It was shortly after this. We filed a patent, but her name is there. And this was a face mask that was developed during COVID. And this is a design patent for this mask. And oops. Just show you, this is what a design patent looks like. It's just look and feel. It doesn't cover any kind of functionality. The back view, the top view. See, we got it granted. That was the file date. The side views. Anyway, it's just look and feel. It has nothing to do with function. So those are design patents. If you have a really cool design, just look and feel. Okay. Yeah, I think that's it. So, so if anyone has questions, we can both address them now. No. Prashanti? Oh, yeah, okay. The cost for the Indian patent. Typically, the cost from start until grant for Indian patent is between 1 to 2 lakhs. And a US patent from start to grant can go from $7,000 to $20,000. So that's why we're very careful with, I want to make sure it's novel because I don't want to waste the money. I mean, we do lose some, but that's typically our cost. Yeah. Any other? Yes. Can you give the mic?
Ma'am, in the patent disclosure form, you are asking about some details about the products, right? So can you explain what are the specifications I need to add, whether only the novelty things or abstract, or what are the details I should include in that?
It's good if you give a drawing, a flow chart, diagrams, and also how it works. If you already wrote the paper, or you have a draft paper, you can send that. But it's also good to have a list of why you think it's novel and why you want to get it patented.
So what if it is kind of software plus hardware things?
You need to show me the block diagram.
Okay.
How it works, what it does. The architecture should be there. Yeah.
Yeah.
Prashanti is going to talk and then we'll have further questions after that. Is that?
So just I also had a question. There's a kind of a recent trend in India for this Australian patents because as you know, patents are also indications of faculty needed for their promotions and stuff. And there's a kind of a racket going on. Many people are calling and asking, we'll give you an Australian patent. It's going to be granted in 8 months, 9 months. But I think there is some illegality about that also. Can you just guide on that? Because somebody make there are con calls coming.
Is this someone? Okay. Do you want? Okay. So Yes, this was, okay, this racket, it's really unfortunate. I don't know why there's so many con artists in India, but this is really, what happened was you can all hear me, right? You can hear me in the back? Yeah, okay. There was this, Australia wanted to promote innovation. So then they had an innovation patent, which could be granted within 7 years. It was very fast. And what started happening is these companies in India would search papers and send these emails to Indian researchers. They weren't even Australian companies. This patent is no longer valid in Australia. They don't even have the innovation patent. It's kind of gone because it didn't do what they wanted it to do. It became like, so really, if you get solicitations, oh, your paper's really novel, you should patent it, blah, 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 please send it to me. Please check with our office. Some people did apply for this and they got patents, but they're not valid. It's kind of gone. They disappeared. The Australian office revoked the innovation patent. I tried to send some circulars, but I don't know. I was hoping they got to most of the faculty when this was happening. But really, if you get, and then some people will say, oh yeah, give me your trademark, I'll register it. Or give me this, I'll do it for you. Please check anything IP related, please check with our office. Yeah. Anyway, the university will cover the costs for all these things. We have quite a few trademarks. The university owns them. We pay all the fees. You don't have to, and those guys will get money from you to do it too. And then it's not valid. So does that answer your question? Yeah, so please tell your colleagues, those kinds of patents are not. they're not- And patents have to be maintained. So we pay the renewal or annuity fees to maintain the patent. It's like you've all played Monopoly, right? You all know the game Monopoly. Oh, yes, right? So you get property, you go around the board, you have to pay your rent. Same thing with patents. You go around the board, you have to pay your annuity to keep it live. Yeah. Any other questions?
Yeah, well, many research scholars are here. So I just had the, suppose I'm just, going in a very possible situation, idealistic situation. I'm doing some cutting edge research, right? If I'm a researcher, I assume I'm a full-time PhD scholar. I mean, I've just joined Amrita. I'm not clueless about the processes. I know there is a patent office. I know there is a commercialization thing. I'm doing some research. Can you give me some timeline? See, I've done some work. I published my first paper, some sort of timeline, like a guidance that, when I should probably think about patenting, and that timeline, how does it work?
So first of all, the university has 4 types of assignment agreements. One is for employees, which the HR manages. There's 2 assignment documents. It's assignment and confidentiality. There's 2 for students. One is paid and not paid, or whether they get a stipend or not. Before anybody walks into your lab to do any research, they should sign those documents because that protects the IP of the lab and the university. I only ask for these documents when I'm filing a patent, but they should be signed before anybody steps in your lab. They're very strict documents. They protect the IP and the confidentiality of all the research that goes on in the lab because we've had people walk off with our stuff. So that's the first thing. Then, and then once if you have an idea and you feel like it's really an innovative idea, you should contact a patent office, fill out this form. Even before you're drafting your paper, we should evaluate the technology, how patentable it is, and when we can file. You know?
Sure, you can also start off with signing that NDA, so non-disclosure agreement where the faculty should have that signed with all the researchers because we are all discussing patentable products. And like we said, this is property and it has value. So we don't want it to go outside. So start with that. Then the assignment agreements. And then whenever you feel it's generally your instinct, you will know there is a value to something. It's nobody's going to feel bad if you come and ask. We all want everyone to come and ask. So Selma is 100% available. I'll also be there. We encourage everyone to come and talk to us.
And when you're at conferences, just be careful what you say, how you say. You can talk about your ideas, but don't disclose. Be very careful about disclosure. Yes.
I have a question regarding the patent. Um, you said like it has to be done in each country. So if it is done in one country, if somebody does it in a different country, like knowing that it is already patented over here, like can we claim something over there? Like mainly with the, when for example for the Chinese products, then they try to like copy the design and they produce it over there.
So you made the design here and they produced it there?
Yeah, I mean like we already have a patent over here, but can it be again like we have to
I
do it
think
in
what
each?
he's saying is you did a patent here, but somebody else kind of did a similar thing and patented it in another country.
You have to contact us. It's an infringement. So we have to stop them.
But internationally, it's possible. It's not like only in India it's valid.
Unless you go and patent it in that country, because patent is not worldwide, it's territorial. If you have it in India, you have it in India. But if you go through WIPO, then you have a better chance because they have the treaties. If those countries come under the treaty, the 150 countries that we talk, then you have a better chance. But still, it's extremely expensive litigation. Most of us give up. Yeah, but basically, it's not a worldwide; it's territorial. We can oppose, but
Yeah, it's
there is a
called-
process.
Yeah, we can do an opposition. So basically, let's say we file the patent. Here's your idea, you got it granted. Then later on you hear, oh, there's this Chinese company, they're doing the same thing. As soon as you hear, you should tell us. Because there's things we can do, but there are, even in India, once the patent gets granted, anyone else can come within 12 months and oppose it. And say that I already did this in this place. You know, there's some things we can do. But unless we file the patent there as well, that gives us the most protection. So if we file the patent in India and in China, and then there's a Chinese company doing something, that's when we can really take action, right? Because they're infringing on our patent. Yeah, but I filed the patent there.
Oh, you already filed your patent in
No, no,
China
no,
too?
no. I'm just saying, that's how we get the most protection, is if we file the patent in
Yeah.
India and China. And then you find a Chinese competitor
Yep.
doing the same thing, then we totally have the right to take action.
You have to go file in China too if you think Chinese, this is something attractive for China. So that's why people file in India first, here in India, and then they file in the US. Because once you file in US, a lot of treaties come into place. A lot of protection is there because US has a lot of treaties with different countries. That's where the protection comes in. On its own, standalone, this is territorial. You file in India, it's in India. You file in China, it's in China. It doesn't go outside the patent is only for the country. There is no worldwide patent. So, no. But WIPO is an answer to that. A large extent.
We go through this WIPO, what would be a ballpark in terms of the cost? Suppose that we're going for a global kind of thing, a ballpark, just
So,
few $1 million, something like that.
no, it's called a piece. I just want to finish this one conversation. So one thing I want to clarify is if you have an idea here, we do a prior art evaluation. Let's say that Chinese patent's already there. We can't file it in India because that Chinese patent is already existing. So your idea, even though you thought of it here in India, it's not novel. So patents worldwide are considered for patentability. Am I explaining that properly? Because it happens to us a
Based on
lot.
WIPO treaties, but on its own, it's not. But because of all these treaties, all the countries signed,
We cross.
we come under certain restrictions now. But if you just look at patent, it's on its own. It's you can file in China. Somebody can file in China, but I filed here. The only issue is because of the treaties that we signed. They and those are enforced. And it's extremely expensive to enforce. So generally, people don't even.
Yeah, so most of our, India's signatory to most of those treaties. So when we do the prior art search, the lawyer, like I have a case right now, the invention is very similar to a Chinese patent. So the lawyer's like, this Chinese patent is very close, so tell me how yours is different. And vice versa. Does that make sense? Okay,
So, I was just asking if you're going for the WIPO PCT kind of thing, what would be the cost like? I mean, in terms of a ballpark.
so actually, the PCT patents are super expensive. We don't normally do them. It starts at around 3 lakhs or 5,000 just to file. That's a starting amount.
It's not even patent filing. It's an patent
Oh,
application to file a patent.
okay.
It's not even the actual filing that starts. So you file your PCT, which is an application to file in multiple countries, and then they do an evaluation and they'll come back and let us know there is something in China. Can't file in China because it's already there. There is something here, there is something there. And so they'll then we are not wasting money filing in China and then getting a opposition
Right,
like is
right.
there. So this is more like a streamlining that they're doing, but very new.
No, it's been there, but we choose which country we start. So if we want to do a PCT, which is recognized all over, it gives you 36 months to file in multiple countries.
Oh,
We choose where we start. So we can choose to start in the Indian Patent Office or the US one, but we don't do those typically. We did it a while ago, but really, we only do those if there's a commercial contract and a company is going to pay all those costs. And it's mainly done for drug patents.
The reason the drug patent, because the patent is 20 years. After the 20, so after you file your patent, the drugs have to go through FDA clearance. That's the 10-year. So the drug companies only get up to 10 years to actually sell the product. So they come up with this because here, once you're in the app, you get 30 months to do the 36 months instead of the 12 months. So there is a lot of reasons for all these things.
Yeah, it gives you, the PCT gives you 36 months to file in 150 plus countries. So you do, mainly it's done for drugs. Any? Oh, yes. Can you give them my?
Namashivaya, are there any emendations possible in the claim sections of the patent towards the end that we have shown? So once it is the patent is approved, are there any emendations possible within that time
Yeah,
period?
so during the prosecution where we go back and forth, we typically amend the claims. But after it's granted, we can't do anything. But during that prosecution back and forth, we actually have a negotiation, and the claims typically get amended. And that's when you can make changes and the other thing is, we do this a lot. Once a patent is granted, the patent office says, oh, do you have any further research? If you do, we do something called a continuation patent. Normally that's granted within 12 months of the original. And it allows you to add on your research. We have a lot of those. And so then you end up having a patent product family. And we have that in quite a few cases on campus, and it helps boost up our numbers because I don't start from zero. I start from the grant. So then it adds on all these other technologies and patent numbers. Does that answer your question? Anything else? Shanti? If there's any more questions after, we're happy to take them. I'll just. Just close it.
so I just adding on to what Salma ji and Jayashree ji told, just wanted to update, the about some facility about the, especially in terms of pre-incubation and the incubation thing. So as you know, we have a technology business incubator in the Amritapuri campus, which is ranked the best in the country. Hopefully, touch wood, in the next 6 months, we have got approval for an incubation center, which is led by the corporate and industry relations. Hopefully, in the next 6 to 8 months, this incubation facility will also be available in our campus. We are working towards it. I mean, it's been granted officially, but there are some kind of legal and other requirements that have compliances that have to be done. Meanwhile, Dr. Krishnashree ma'am, Dr. Krishnashree Achyutan, the Dean of Postgraduate Programs, has a center called the DST-Amrita Technology Enabling Center. So Dean Engineering has asked me to help in these efforts and coordinate this activity for 3 of our campuses. So there is some support. Mainly the Technology Enabling Center does a lot of pre-incubation support. So you know the journey, right? You have an idea. From an idea, you move to a proof of concept. From a proof of concept to a prototype to a product, and a product to the startup. That's the kind of the flow of the life cycle, so as to speak. But you have millions of ideas. The number of ideas that move from an idea to a proof of concept, that number gets reducing. From proof of concept to prototype, again reduces. Prototype to product, very few. And product to startup, just in the, you can count it in, with your fingers. That's the kind of the entire system in the country. So the enabling center helps you in that journey. So of course, for this you need to patent, right? Then only you get protection of your your intellectual property, all various types of intellectual property. So that's a mandatory thing for all of these. But in this journey towards idea to proof of concept to prototype to product, and product to startup, this technology enabling center will provide a lot of support is there. And in terms of the support is given first for mining the technology. When I say mining, you have some idea, but you have probably it's a wild idea, or it's not an idea that is structured. Now you need support, you need mentorship to kind of convert that idea into a clear proof of concept. You need some idea on what kind of technology, hardware, software, or equipment, infrastructure is needed for that. So that is the first support that is given. That is mining the technology, helping you convert the idea into a prototype. Now, once you have some prototype, the next step is the assessment of the technology. So what level of readiness you are in terms of the technology. So that support is, again, it is offered free of cost by the technology enabling center, where a certificate is given that there are 9 levels of technology readiness. This basically came from a NASA space system program, but now it is kind of universally accepted. So simply speaking, in a ballpark, the first 3 are proof of concept. The next 3, 4, 5, 6 are prototype, and 7, 8, 9 are more into a product level, various maturity levels. So that assessment is also provided by the TEC in terms of the maturity level, the readiness level, then helping in the market study, because you're doing something, you're investing your time and resources, whether there is a scope for that to go to the market, whether it is it is commercializable. So that help will also be given. And finally, the support in terms of connecting to the patent office, to Jayashree ji and to Salma ji, in terms of the patenting, the licensing, the commercialization, all that legal requirements that are there. And of course, the arrangements, in the sense that since the university is paying for the entire process end to end, obviously, if there is a commercialization aspect, there needs to be, what is the kind of, is there a percentage for the inventor? All those things have to be decided at a very high level at the university administration, but those things are facilitated by the TEC. And then, of course, helping you in terms of connecting to partners, industry, connecting to. So, and we also, somebody will ask, what about CIR? Yes, CIR is definitely into this space, helping in the technology ecosystem, helping you connect to industry. The efforts of the technology enabling center are kind of complementary, and we are working closely. For example, now we already have an MOU with Codicea, with the mechanical engineering department has leveraged. For those who don't know, Codicea is the Coimbatore Small Scale Industries Association. It's actually the largest MSME association in India. More than 6,000 members, and they're not big players. They're very small, medium scale industries. We have a existing MOU. Now we are complementing effort. They have a defense innovation hub. We are seeing how our departments can contribute in terms of the defense, supporting the requirements of the defense cluster, because Coimbatore, they're going to from a pump city, and it's going to be a defense innovation hub. So those things we are helping. Then, of course, various kind of activities and so on. So this is just a brief on what all activities that are there. And yeah, some of the things, I'm not sure which of these were patented. I'm not sure, but I know that there is a start in terms of some technologies, as Salma ji mentioned, have been transferred to the industry. Some have been commercialized by us. Some have been licensed and so on. Of course, that decision is taken at the highest level of the university administration. But I am aware that the TEC has already done this. I believe this paper, that is powered air purifier respirator, has been transferred to some company. This wheelchair has been transferred to a company in Chandigarh that is making, it's a maker of wheelchairs, different types of wheelchairs that were developed at the Amritapuri campus. They have already been commercialized to a company that is focusing on wheelchair manufacturing. In that case, the transfer has happened. The nano mask, if I am not mistaken, we have commercialized it. It's from the Nano Center. It's not given to another company. We have only commercialized it. So there are different models, but of course, those decisions on what would be the percentage, whether it should be commercialized, whether it should be transferred, whether it should be commercialized by us, will be taken obviously at the highest level of the university administration. I just wanted to brief you on such a facility is available in this campus. You have any issue, especially with respect to the pre-incubation, please contact me. I will try to support in whatever way possible. I'm already engaging with the department chairs, are already kind of supporting in many activities and so on. Thank you very much. Namaskar. So any more questions for Salma ji and Jayashree ji, please feel free to ask. Any more questions on patenting and stuff? Any support? I mean, you are if you have something that you have already submitted something. I mean, she's very much available, she's extremely busy. So you have already submitted something. You want to know the progress. Those kind of things are also, you can even offline connect with her. Okay. I think there are no more questions. Okay. Thank you so much for this your presence and your attendance in this seminar. Thank you so much. Thanks to Jayashree ji and Salma ji for taking the time out. They had a very hectic. They just came from AIMS. Please give them a big round of applause. Thank you so much. Okay, thank you.